Ladies and gentlemen, gentlemen and ladies, ladies and gents, for the last 3 days I've been getting maybe 9 to 11 hours and 30 minutes of sleep, even falling asleep during the day. Got to make up for that rest I didn't get going through all of that pain. As I told people, I tune pain out, just focus it completely out so that I don't feel it or experience it. That takes a lot of energy, but been doing it for over 30 years now. It works for me. Whew, so glad we got that cleared up. Now look, I know some of y'all really appreciate the information you get in these videos. As I told you, I'm just talking. If only you guys, I'm sorry. I'm sorry. I have to laugh because 3 times today I had conversations with people about things that I've never talked about, never ever even thought about talking about, and then put it through the GPT system to prove that I was right, and then put it through the second GPT system because I didn't want the first GPT system to say that that it was agreeing with me just to be agreeing with me, because that's how ChatGPT has programmed, OpenAI has programmed their junk. So, no, not going to tell you what we talked about. I want to talk to you about something. One of our clients received this notification. I'm going to show you more than what he received. Uh-oh, that's not what I was trying to show you. Ladies and gentlemen, we're going to talk about that because I just pasted. Oh, that's our letter. No, y'all ain't supposed to be seeing that. That's our letter. This is the client's letter. This is part of the letter that he received from a credit union. Because, they are, well, let's let it read it. We're going to start right here responding. They're responding to communications.
Responding to the documents sent by an unauthorized party on your loan.
Unauthorized party. Everyone signs a power of attorney, a limited power of attorney. They say unauthorized. Now, they say that on purpose. They're doing that to try to piss me off. I'm okay. Let's continue.
Unauthorized party on your loan, as referenced in the response letter. In sum, the documents appeared to use unrelated and disjointed legal authority and terminology as a pretense to assert that you had assigned your loan rights and obligations. The purported transferee sought to unlawfully dispute and challenge any obligation.
Ladies and gentlemen, nobody's trying to transfer any rights. We're not trying to take over the assignment of the loan. Ain't none of our documents ever said nothing like that. Don't worry about it. They're doing it on purpose. But look at what they say here. The purported transferee sought to unlawfully dispute and challenge any obligation under your automobile loan. Really? We unlawfully did that? Pay attention. Unlawfully. We have a power of attorney. Let's go on. The loan with the credit union. The credit union reviewed your loan account, confirmed that any pretense of a transfer is putative assignment. It was not recognized, and that a legally sufficient authorization for any third party to communicate on your behalf, legally sufficient. Excuse me? Legally sufficient? Legally don't control nothing? We're not following your policy, stupid mother. I'm sorry. Ladies and gentlemen, a power of attorney is your power. It's not the court's power. They don't get to tell you what you give authorization to or from. You sign power of attorney over to people all the time that are legally sufficient. Why? Because you consent. All it needs to show is you're the person signing it, what authority you're signing over, the date, and your signature. You don't have to prove nothing. Of course, you have to have the account number and all that stuff on it. But anyway, on your behalf would have to be received in order to respond to anyone but you. Pay attention. They do this to people like myself all the time. That's why I do limited power of attorney. That's why I document everything. Our company has been sending out communication after communication, over 60 different letters. We have spent over $80,000 in the last year and a half on these communications. This is not a joke to me. I am using that as evidence against them. So this is our final communication before the lawsuit. No, this ain't the same as that $400 billion lawsuit. $400 billion lawsuit was to help those of you who needed to obtain some credits. we had to produce something that was legally recognized. You follow me? Okay. Anyway, let's continue with this. No, they think they're smarter than me. This was written by a stupid attorney and an executive. They both got together to put this junk together. That's why the offensive tone. That's why authority and legal terminology. That's why they added the disjointed and unrelated. Excuse me? How could it be unrelated when we're talking about the client? My bad. So let's make things clear for them because, they don't have a clear understanding of what's being done here. So, ladies and gentlemen, y'all pay attention to part of what we're writing them.
So that's clear, and spoken from Congress itself, you cannot claim that it's some legal theory or some disjointed terminology.
Mm-hmm.
I am a natural person as defined in law, thus any person applies to me. I engaged in the business of banking as...
I'm sorry, Lord have mercy. Y'all have to excuse me. Let me tell y'all where that's coming from because y'all wouldn't know where I'm getting that from. So we're going to go here. This is the Check 21st Act. This is page 2, section 3, definitions. We copied for the purpose of this act, the following shall apply. Bank. The term bank means any person. So that's why he's saying, see, that means me because I'm an any person. Applies to me. I engaged in the business of banking because, they're saying that it ain't.
I engaged in the business of banking as evidenced by your response. I was the bank or U.S. borrower identified by the Federal Reserve Act Section 13 subsection 13. Federal Reserve Operating Circular 1012.3 identifies me as the borrower pledging the collateral. The aforementioned operating circular identifies the original so-called alleged lender as an agent. That agent and/or intermediary is not a creditor and thus to the contrary is challenged. Jurisdiction may be challenged that time. This doesn't just apply to a courtroom.
Hold on. Wake up. Any. Stop listening. Ladies and gentlemen, it's being proofread now. Not while I'm doing this, but someone else is proofreading it, and so we will catch that. Jurisdiction may be challenged at any time. Now, I was pausing it here anyway, because everybody thinks jurisdiction may be challenged at any time only applies to court matters. That is a lie. Jurisdiction is a foundational matter. It has nothing to do with the courts. Jurisdiction can be challenged at any time. You can challenge anyone's jurisdiction. What you mean you live here? Mother, you don't live here. This is my house. Do you understand what I'm saying? Jurisdiction can be challenged at any time. Hey, man, get out my car. No, that ain't yours. That's mine. Get out my car, mother. Okay? Jurisdiction can be challenged at any time. You just have to understand what jurisdiction is. Jurisdiction is somebody claiming that they have a right to something, that they have authority over something. Okay, so we're challenging their jurisdiction. Let's get this going.
Anytime, this doesn't just apply to a courtroom. I am challenging the alleged lender's claim as to amount to fraud, misrepresentation, misinformation causing damage to both my person and my property because such has been relied on constituting the elements of fraud. I have accused you of unjust enrichment, conspiracy, and other so-called disjointed claims amounting to violations of both local and national RICO statutes. Automatic quote first rule. Jurisdiction, once challenged, cannot be assumed and must be proven to exist before a court may proceed to judgment. Main v. Thibodeaux, 448 U.S. 1, 1980, citing Higgins v. Lavine, 415 U.S. 528, 1974. Mandatory legal syllogism. Major premise, jurisdiction is a threshold issue and must be established before any proceedings, as per Supreme Court holding.
Now, that is taken from here. That will be reworded. Why? Because jurisdiction may be challenged at any time. This is its automatic first quote rule. It must quote a law. Now, a challenge to jurisdiction can be raised at any stage and not solely in a formal court setting. Conclusion of law, jurisdiction may be challenged at any time, and this principle applies beyond the courtroom, including administrative, executive, private, corporate forum, where authority is asserted over a private civilian. Now, hold on now. Some of y'all didn't know this. I knew that. I just shut up. Ain't nobody been saying nothing like this on nobody's video, because I done heard y'all talking. All of the people out there claiming they know what they talking about. Everybody, I challenge your jurisdiction. Everybody out there talking about challenge jurisdiction, and they don't even understand the premise of challenging jurisdiction. So let's do this. Remember, I'm the guy who made the statement in the first place. Jurisdiction can be challenged at any time, and anybody's jurisdiction can be challenged. Your analysis captures the critical legal principle, the necessity of jurisdiction as a prerequisite for any valid exercise of authority. A servicer is claiming that they have jurisdiction over your loan, that they can dictate anything. They're not the dictator. They're just a servicer, and if the contract has already been satisfied, they have no jurisdiction. That's what we're saying. The promissory note amounted to collateral and security. Hold on. Want to make sure y'all understand, because some of y'all don't understand. Y'all like them parents. Let's do clients. Because like I said, we have to proofread it. It's all done, but let's do this so that we can get this in here for y'all. I know y'all gonna want to copy it. I don't care. Let's make sure y'all understand this thing about jurisdiction. As I stated, no, I have challenged your jurisdiction. I've challenged your standing. I demand verification, not validation of the debt that is alleged. I have pointed out the law that I'm relying on. Doesn't matter whether or not you agree. What matters is your obligation under contract and under law. The promissory note is the collateral and security for the issuance of Federal Reserve notes. Give them the actual law. Such application shall be accompanied by or with a tender to the local Federal Reserve agent of collateral in an amount equal to the sum of the Federal Reserve notes. Wait, hold on now. 12 U.S.C. 412, that's what it says, equal to the amount of Federal Reserve notes. Equal value to an amount. That gives you the value. That's par value. You gave them something of value equal to the value of what you were receiving. There is no more contract. Shh. Hold on. It doesn't just say it just once, because we don't want to have no disjointed legal theory. We don't want to say, well, that's what that sovereign citizen EeoN says. Let's do this. In no event shall such collateral, what collateral? The tender, the collateral that was tendered. Promissory note is the collateral and security for the issuance, accompanied with a tender of collateral in an amount equal. Well, in no event shall such collateral that's in an amount equal be less than the amount of Federal Reserve notes applied for. Twice it says par value. That gives you evidence and intent of Congress. They don't want to play with me. This is what I do. Under the new law, the money is issued to the banks in return for government obligations, in return for bills of exchange, drafts, notes, because it is backed by the credit of the nation. Shows you it has value. So again, I said no. You are acting like you're in charge, like you're in control, like you're a creditor of this agreement. You are not even a party to the agreement. So no, stupid idiot. That's what we're saying on your behalf. Our clients are getting this letter. You're getting this letter. You got to send it out. This is for you. You want to argue? I am not arguing with you. Stop sending junk saying that it is a direct response to my lawful request. It is not. Stop sending all this junk. Sending all these letters talking about here's a copy of the note and here's a copy of a history. Do you understand the company who sent us that letter said we sent a copy of the history? Who asked you for a copy of history? Lord have mercy, go talk to Michael Jackson. He did an album for you. But we don't need your history. We said a verified, comprehensive accounting. That's not a stupid statement. That is principles of contract law. Uniform Commercial Code, Article 9, Section 210. You ask for comprehensive accounting and a list of the collateral. Very important that you ask for a list of collateral, not just comprehensive accounting. All right, now look, we're going to leave you guys with this, because if you go back and pay attention, there were a couple of things that we said that have not really been said by people before. And if you bring this stuff up in court, you should do okay. Go back, look at what was written in that letter. Jot it down for yourself. If you are a client, give it a couple of days, because we got to proofread it. But you will be getting a copy of the letter, and we will be sending out a letter, the copy for the company. There are 2 letters, people. Ladies and gentlemen, let me get rid of you. We ain't saving you. Don't need to save you. You did that only for the video. Let's see the answer. This is the answer. This is client notification. So this is one for the client. Okay, this is for the client. All right, for the client. But then we have one for the foundation. Okay, got one for the EeoN Foundation, because that's who they're going after. So the EeoN Foundation will be sending out that letter for you on your behalf, and you'll be sending out one. See, we've already sent out enough information for them. We need them to violate your right to power of attorney. We need them to interfere with your right. But now we're going, this lawsuit will be different than the one $400 billion. And this one will be filed differently. Not so that they could dismiss it like they did. Oh no, we're not playing that. We're going after a different party this time. Because this is how we do it. Because the courts are corrupt. I'll say it. The courts are corrupt. We just had to prove it, people. We had to prove it. Now that court in Washington has responded again to what we sent. Because you know how they were being stupid, talking about they were going to dispose of the matter? Well, now they're trying to CYA. I'm okay. Don't worry about them. They're not the problem. I'll tell you how to handle them. All right? Be patient. All right. Have a good day, y'all. Take care of yourselves. I'm out of here.